Hello. This is part 2 of chapter 9, and we're going to be picking up here starting off with patents. I did want to say I forgot last time, contractually obligated to give a shout out to my tech support. My tech support is working remotely right now. He's not here anymore. He has to stay a little further away, but I do have to give him a shout out. So, hi Grant. All right, so patents. We're still in the chapter on intellectual property law and the internet, and we're still talking about how do people protect their ideas, the things that they are using, the things that they are creating, and in this case, maybe the things that they are making. How do they protect them so that the public gets a fair share here, where they're not confused, they know what's going on, and that they get paid for their ideas, which we want to encourage. Okay, patent law is, again, it is federal law. It covers the whole United States. We do not have 50 individual states with their own rules, and the patent is obtained by filing in the United States Patent and Trademark Office located in Washington, D.C. All right? So there are 3 main kinds of patents: utility patents, design patents, and plant patents. The utility patents are, and sometimes they're called functional patents, they give inventors, and if any of you know any inventors, and I know a couple, if they have 1 patent, they have 100. They seem to have a mind for developing new things, and they want to protect those, rightfully so. Will they ever make any money from them? Maybe, maybe not. But they really need to protect their ideas and the way they have manifested those ideas in order to get paid, maybe eventually. All right? So the utility or functional patents, first of all, it has to be a new and useful. I guess maybe we sometimes disagree over what's useful or not useful, but the office is the one that decides. You do have the right always to challenge their decisions, but they're going to make the initial determination. It is the new and useful invention, new and useful process, new and useful machine, a new and useful manufacturing, a new and useful composition of matter, all Teflon, all the new products that we have in this world. And of course, it's the new and useful improvements to any process, machine, manufacture, or composition of matter. All of those can be patented. The patents last for 20 years. You can get a grant. We have a multinational trade agreement that does this now, and it's 20 years. The World Trade Organization, that was their rule, it was 20 years. And you could have the patent. Now, if you get a patent for one of these process machines, etc., you have to file it, and then it becomes public information. And anybody who is looking to get a patent of any kind has to realize that it is public information. Sometimes at craft shows, and we've talked before how I go to a lot of craft shows, at craft shows that you go to, you will see people who are selling as artworks the submissions that people have given to obtain their patent. Some of them are very interesting, they're very complex, and they make nice pieces of artwork, which they then sell. The second type of patent is a design patent. Let me back up just a moment and talking a little bit more on those utility and functional patents. Sometimes we come into an argument, I guess, that I'm assuming that most of the pharmaceutical companies have these types of patents on their products, but it's an argument now about how do we get more generic products on the market. How do we prevent them from slightly altering their original patent so that they can extend and get a new patent on essentially what some people consider to be exactly the same thing. We have not gotten a resolution for this yet, and I'm assuming sometime, probably more in your experiences than in mine, we'll have to get a resolution for that. Okay, so a design patent. A design patent is a new, and again, it's got to be non-obvious, that it's an ornamental feature that appears in connection with something that has been manufactured. They last for 14 years. And I think actually that, and I think the book says this too, there are actually more frequently issued than utility patents or functional patents, is these design patents. But it has to be a non-obvious feature and before it can be patented. For example, a lot of the toy companies get a design patent for the parts that they put into the games and the toys that they have, so that when you pick up a particular game and you see that, you know it's always going to have those kinds of parts, and they are marked. Trademarks have to be marked. You have to have the fact that you've got the trademark on there, and you have to have the word patent and a number. And you'll see a lot of products that say patent pending and a number. It means that they have applied for their patent, but it takes a little while for all the processing to go through and everybody to look at it. So it may be patent pending, and that has to be marked on the product if later on you want to try and enforce your rights for that. All right, there are plant patents. Plant patents are for obviously plants, and therefore are things that are being reproduced asexually. You're going to have new varieties of plants. And plant designs last about 20 years from the date that they're filed. And although it only mentions them in the book briefly, actually plant patents now are coming into more and more popularity. Okay, in 2011, which again is a very, very recent law in terms for us, we have the America Invents Act. And the America Invents Act kind of changed what we do, but it says that we are now going to have a first to file system. First to file system means that whoever is the one who files with the patent office first is the one who is going to have a legitimate patent. Used to be first to invent. But that evidently became very difficult in some cases to exactly figure out who was the one that was first to invent something. So we have changed to first to file, and that's under the America Invents Act. Again, recent, 2011, it's pretty recent. All right. Some things you cannot get a patent on. You can get a patent on processes, which includes some business methods. You can get it on machines. You can get it on manufacturers. You can get it on composition of matter. You cannot get it on phenomena of nature, mental processes, and abstract intellectual concepts. Because those everybody has to be able to use for scientific and technological knowledge, and we want people to be able to do that. All right? Anytime that we're looking for a patent, it has got to be something that is new. It has got to be something that's not obvious. And it's not obvious to a person of ordinary skill and knowledge in the field that is about that particular product or process or manufacturer that you're trying to patent. So we might not be looking at me now because I know nothing about it at all. So to me, anything would be new. but to somebody who actually works in that field, but it's a person of ordinary skill and knowledge, not a specialist that we have to look at. Would they think that this was something that was new and not obvious? Once the Patent and Trademark Office grants the patent, approves it, then it's presumed valid. If there's a lawsuit about it later when you're trying to enforce your patent, then you may have the right to challenge that, but it is presumed to be valid when the Patent and Trademark Office says, yes, this is something that we found to be new and non-obvious, and we've given a patent on this. All right? All right, so this patent owner, once you have it, has the exclusive right. And exclusive, again, means that it is the right to use it, make it, sell it. You've got the rights to do those things, and you have the sole right to do those things. Okay, secret business information. Let's talk about that for a little while. It is possible that a business doesn't want to disclose everything to get a patent or to get copyright protection of, say, a computer software program. You don't have to get a patent if you don't want to. You don't have to get copyright protection. And the reason that companies might not want to do this is because then it becomes public information, and anyone, including a competitor, could go to the office of patents and trademarks and find out what it is you're doing. If you keep the information secret and confidential, then it is protected under state law usually as a trade secret. It's still a confidential thing, it's still a secret. And even though you don't have the copyright or the patent, it's still given some protections. So in order to be a trade secret, it has to be information that would give you an edge over a competitor that doesn't have that information. So that's what we're talking about. We're talking about a competitor that doesn't have the information. If they had it, would it make it easier for them to get an advantage over you? And that's what you want to prevent. All right? Sometimes courts are going to protect confidential customer lists, but they'll only protect these customer lists if it's not easily, I mean, if you couldn't just go on the internet and open it up and figure out who all your customers were, that's not secret. It has to be something that's secret. And one of the ways businesses try to keep this secret is, when you're hired, you have to sign a non-disclosure agreement that says that this is the information this company has, this information is private to this company, it's confidential, you know that when you begin employment here with us, and you sign a piece of paper, you sign a document, you sign something saying that you are not going to tell anybody this information if you leave. If you violate that, there are usually civil penalties, you can be sued, and criminal penalties, although in Michigan, it's only a 1-year misdemeanor for giving up trade secrets on the criminal side. So probably the civil side would be more of the issue at that point. But those non-disclosure agreements are a really big deal. And if you sign one, then it covers when you leave the employment. You don't get to take all the information with you and give it to somebody else. The non-disclosure agreement says that you won't give it up. There are criminal sanctions under a federal law, the Industrial Espionage Act of 1996. Again, relatively recent law that says that you can't give up information. Now, it does say that whoever owns that information they have to have taken steps to keep it secret. They have to have taken some kind of action to make it confidential. And there are some really severe penalties for violating this act now. It's a fine of up to $500,000 or twice the value of the property that you leaked, gave to somebody else, and possible imprisonment up to 15 years for an individual. That's a pretty severe penalty. So it's something that businesses can do when they're trying to make sure that they're not putting all the information out in the public by obtaining the patent or the copyright, but they still want to keep the information secret. So you have your employees sign the non-disclosure agreement. The employees have to take that very seriously and not give up the information. Okay, we also have some acts specifically, and these are all, this one's a little bit older, but they're relatively recent laws because so much of what's been going on in this area with the internet, with computers, is relatively recent. So we have the Copyright Protection of Computer Programs, which is the Computer Software Copyright Act of 1980. And this says that it is going to allow protections for computer software. And it's going to allow it, and they'll look at their structure, their flow, their sequence, and their organization. And then they look at what are the significant steps of the software program. Have they been copied by somebody else? All right. But again, there's the same issue with the computer software programs as there is with some of the other patents and copyrights. Is, do you want to put this into the public record? Or do you want to try to let someone else, and so maybe you don't want to put it in the public record, but you don't exactly want to keep it secret to yourself either. You want other people to be able to use it, then you do it by licensing. That certain people will be allowed to use your program under certain licensing agreements. Okay, on page 174 of the book, it has a really good outline of the types of intellectual property that there is, and you do need to know the types of intellectual property that there is. And you also need to know what is protected, why we have these particular types of intellectual property protections. What are they protecting? I probably would never ask you what the duration is. Sometimes that changes, some of it's been changed recently. Just know that it can be kind of a long time. And then find out what the standard is. So that's what you really need to know out of this chapter, is you need to know what the type of intellectual property, well, you need to know first of all what intellectual property is. And then you need to know what kinds of intellectual property there are and how we go about protecting that kind of intellectual property. Okay? Thank you, and the next chapter that we are doing now then is going back to where we were before, and it is chapter 20, Personal Property and Bailments. Again, this is a rather lengthy chapter. There's a lot in that, and then I'll tell you frankly, the chapters start to get much shorter. Please remember to look at the scenarios online, pick one. If you know someone else from the class and you are able to work with them, that's fine with me. Go ahead. This was a project that we were going to do as groups in class. So if you have other people you want to work with, go ahead and work with them. That's fine with me. Just I'd like to know who it is you're working with. All right? Any questions? Make sure that you email them to me. Goodbye.